PTPGun.com's presentation of Maryland Firearms Laws. I'll be instructor for today, Ryan Gass, and we're going to go ahead and get into it. All right, so I am not a lawyer. I do not claim to be. Kudos to all the lawyers out there that are watching. But what I'm not doing today is I'm not giving you legal advice. I'm simply just telling you what the laws are and how they are set in Maryland. So in Maryland, in order just to be able to buy a handgun, you have a HQL that you have to obtain. And this will be part of the training that's required for that. What is HQL? It's short for Handgun Qualification License. In order to get that, you must have the required training. You must also get your live scan fingerprints, and you also must go ahead and take both of those and you go onto the Maryland State Police website and you apply for that. If you go to our website, PTPGun.com, we have a full blog article on how to apply for that HQL as well as other licenses you might be seeking. This training that we're also going over with Maryland Firearms Laws, this is also used towards those who are seeking to get their Maryland permit to carry a handgun. Maryland does issue a permit to carry a handgun, and that is issued also by the Maryland State Police, and you can also go through the Maryland State Police online portal to apply for that as well. But getting into it, here's Maryland law. Main topics that we're going to cover today are going to be where to find and read applicable laws, disqualifying factors, restrictions on carry, and transportation, because to carry a firearm and to transport a firearm are two totally different things. We're also going to go over Maryland case law and self-defense, interacting with law enforcement, as well as how to find legal counsel. So what you'll see here is actually an interactive map, and this is going to be flipping through the years, showing you how or if states issue permits to carry a handgun or variations of. So what you see, the states in red are those who actually do not issue a permit at all. The states in yellow are like how Maryland is, where they are a may issue state, where you can meet all the requirements, you can be the greatest person in the world, you can pass your background check, but you still may or may not be issued a permit. The states in blue are like a lot of states tend to be, what's called shall issue, where if you do the training, you pass a background check, you do all the proper paperwork, you shall be issued a permit. And the states in green are like how Vermont's been for decades, where, in example, Vermont, as long as you're 16 years of age or older, without training and without a permit, you can open or conceal carry a rifle, a pistol, or a shotgun. And that might sound crazy for a lot of our students that actually have lived in Maryland for a long time because of Maryland's restrictive gun culture and their restrictive laws that have been placed on them by their politicians. In Maryland, like I said, you don't have to have an HQL just to be able to buy a handgun. You have to have a permit just to be able to carry open or concealed. People don't really know and understand, don't really exercise their ability to carry long guns. So this sounds really crazy for a lot of Marylanders. But when you think about Vermont, what do you think about? Do you think of outrageous crime levels, violent crimes, murder rates, and stuff like we see in Prince George's County, Baltimore City, and other parts of Maryland? No. When you think of Vermont, you think of Bernie Sanders, Burlington Coat Factory, and Ben & Jerry's ice cream. Right? Is that to say or ignore the fact that violent crime does exist in that state? No, I'm sure it does. I know it does. But it's the same levels that we experience in very restrictive states that do not respect the Second Amendment? It's not. Now, what is reciprocity? Reciprocity is more or less a formal agreement that's signed into existence by attorney generals of the two states, or the governors even, where they will say, hey, if you recognize our permit, we will recognize yours. Does any state have that with Maryland? No. Maryland does not have any reciprocal agreements with any other states. Now, you also have reciprocity and you have recognition. Now, recognition might be where, like in Virginia. In Virginia, they passed a law that states that if you have a permit from anywhere in the United States, your permit is recognized in Virginia. So while Maryland doesn't have a reciprocity agreement with Virginia, Virginia does recognize by their law, they recognize the Maryland permit. Virginia, if you have a permit from anywhere in the United States, any one of them, whether it's Maryland, D.C., Virginia, Florida, doesn't matter. It doesn't matter whether you're a resident or a non-resident, they will recognize your permit. But again, Maryland doesn't have reciprocity with any other states, and they don't have recognition with any other states. If you want to carry in Maryland, you must have the Maryland permit to carry a handgun. Now, like we talked about earlier, does Maryland have a permit that you have to have or a license you have to have just to be able to buy a handgun? Yes. And again, what is that called? HQL, Handgun Qualification License. And that's what this training is a lot of times used for, so people can be able to meet the training requirements for their Maryland HQL. So with that HQL, it allows you to buy handguns. You do not have to have the HQL if you've already owned handguns. Let's say you bought handguns or they were handed down to you years ago before October of 2013. If you have those firearms from that prior to that time, you don't have to have an HQL to possess those or to use them or to take them to the range and shoot with them, or if you get your permit to carry a handgun, to carry it. An HQL is just so you can buy more handguns, or you can buy, if you never owned firearms before, so you can buy your first handgun or buy any other handguns. All right. Now in Maryland, is there a permit you need in order to carry a handgun? Yes. And how Maryland does it is, without a permit to carry a handgun, you cannot carry that handgun openly or concealed. With Maryland's permit to carry a handgun, it allows you to do both, open or concealed carry. Now, they do it a little different than a lot of states, like Virginia, Delaware. A lot of states, you're allowed to open carry a handgun without a permit, but with a permit, it allows you to conceal carry. So a lot of times they will call their permit some variation of that, whether it's concealed handgun license, concealed carry permit, concealed carry of a dangerous weapon, like Delaware does. But Maryland is a permit to carry a handgun. It allows you to do just that, open or concealed. It doesn't limit you on whether you carry open or concealed. It doesn't limit you on how many guns you carry. It doesn't limit you on how large those magazines can be. You can carry a handgun, right? Now, whenever you go to buy a handgun in Maryland, you're going to have to complete what's called a 77R form. That can be done on the Maryland State Police online portal, whether you're at home or you can do it at the gun shop at the time of the purchase, but you'll have to do that in order to purchase a handgun. That's on top of the state and federal forms you've already had to fill out. You have to do all those in conjunction in order to complete that process in total. Now, in order to apply for the HQL, again, you must have your training done and you must have your live scan fingerprints done, and then you'll be able to go on the state police website to complete the application process. When you do that, the state police, they will collect a $50 application fee. When you apply for your HQL, make sure that you, again, have the training done, the fingerprints. The fingerprints, though, they're only good for 30 days. So once you get those fingerprints done and you've got the training done, make sure that you apply online before that 30 days expires. All right, so what I generally tell people to do is don't get the fingerprints done until you've completed the training. Now, when you apply for the HQL, as of right now, it takes them about 2 to 3 weeks to get back to you, but they have up to 30 days in order to get that HQL back out to you. Once you get that HQL, it's valid for 10 years, and in 10 years, when you go to renew, you won't have to do fingerprints over again. There's a $20 renewal fee, and again, as of right now, you can do it all online. Do not let it expire. If your permit, let's say it's a Friday, and that's the day your HQL expires, but they don't get your application for renewal until that Saturday, you will have to now do the training over again. You'll have to do the full application fee, and you'll have to get the fingerprints redone. So don't let it lapse at all. You want to reapply, you want to renew it before your permit expires. And that same thing goes for that permit to carry handgun as well. Now, whenever you buy a handgun, you have to have that HQL with you, as well as your driver's license. Once you have the HQL and your driver's license, you go down to any Maryland gun shop and you can go ahead and do a purchase of a handgun, and or go ahead and transfer a handgun that's from the ownership of a friend or a coworker or somebody at church. They can transfer that ownership to you once you have that HQL. How that'll generally go is the dealer or the person facilitating the transfer, they will need to see, again, that driver's license and your HQL. They will facilitate having you fill out all the proper paperwork, and then they will say, all right, you can go ahead and pick up your handgun now in 7 days. They can't give it to you then. That's by Maryland law. I don't like it, don't agree with it, but that's how it is. There's nothing you can pay that dealer in order to get that handgun quicker. Otherwise, they and you would be violating state law. Now, LexisNexis is a database in which many jurisdictions, including but not limited to Maryland, upload their laws for viewing, so you can see and read and understand what exactly the laws say and what they don't say. It's a very plain Jane, black and white website, and it's accessible from any computer. Now, Senate Bill 281. Senate Bill 281 is one of the reasons why a lot of people have to do the HQL training, is because Senate Bill 281 went into effect in October of 2013, and that did several things, including but not limited to require that you have an HQL just to be able to buy or transfer a handgun. Also, it banned magazines that hold over 10 rounds. Now, with that being said, the HQL, Handgun Qualification License, know that your Maryland politicians are trying to do the same thing with long guns. We saw in 2020 with the coronavirus where a lot of people were going out to buy firearms and they learned of these gun laws that have been around for several years now. They learned, oh, I can't buy a handgun of my choice because I don't have an HQL. And they didn't have the time or the money or the ability to be able to go out and get that HQL, and they didn't want to have to wait. So a lot of them opted to buy long guns because that right wasn't obstructed by the state. Now, with what Maryland politicians are trying to do now, they are also trying to do what's called a long gun qualification license, where they will, best way to explain it is, let's say with the HQL. The best way I can explain it to you is, prior to October of 2013, you had the right to be able to buy handguns. What Maryland politicians did was they stole that right from you and they sold it back to you. They say, hey, if you pay this instructor this money, if you pay this fingerprint tech this money, if you pay us this money, we will give this right back to you so you can legally exercise it that we stole from you. They're trying to do the same thing with long guns, and if you don't voice your opinion, if you don't speak out, if you don't let your voice be heard, that will happen with long guns. So now let's say the next pandemic or the next situation pops up where you or somebody else like yourself might want to go buy a firearm. You have no ability to buy a firearm, long gun or handgun, unless you have these licenses, whether you have paid the fee, the fine, to be able to exercise your constitutional right. So make sure that if you don't want your rights further treaded upon, then you need to go out there and you need to let your voice be heard. Now again, Senate Bill 281 did several things, including the HQL, but it also limited the amount of capacity your magazines can hold. And let's talk about that. How it's worded is, a person may not manufacture, sell, or even offer for sale, purchase, receive, or transfer a detachable magazine that holds more than 10 rounds. Now, take a look back. What does it not say? What does it not say that you can't do with that magazine that holds more than 10 rounds? How am I able to legally be able to possess this magazine right now that holds 17 rounds in the magazine? How am I able to do that and not be breaking the law? Well, again, look. It says that I can't manufacture this. I can't sell it. I can't even offer it for sale. I can't purchase, receive, or transfer this magazine in Maryland because Maryland law only affects actions that happen in Maryland. What it doesn't say is it doesn't say that I can't drive with it. I cannot bring it into the state. What I can do, what is not stated that what is not limited or stolen from me is I can still go to Virginia and I can buy these magazines and I can bring them back into Maryland, and that's perfectly fine, perfectly legal. All Maryland politicians did with this ignorant law was to not only tread on your rights, but they made they helped Virginia businesses, which is all great and dandy. But I'm sure Maryland gun shops would love to have the ability to sell these products to their customers, but they can't because they had that right stolen from them. So again, I can still own this, use this, shoot with it, carry with it, this magazine that holds more than 10 rounds. Maryland doesn't limit you on how big a magazine you can own. You just cannot make that transaction happen in Maryland. You can't go down to your local gun shop and buy them. You can't trade your buddy for something. You can't barter with your buddy or whatnot for that magazine holds more than 10 rounds. You go outside the state bounds of Maryland, you can do that and you can bring it back in. Food for thought. Now again, like we said before, if you buy a handgun, you will have to wait 7 days in order to be able to take possession of that handgun. So let's say you buy it on a Monday, you do the paperwork and all that stuff. Again, you have to come back the following Monday. If you're not disapproved by the state police, then you can then pick up your firearm. Because when you do your background check and all your paperwork with the state police, they never approve you to buy a firearm. They never approve your ownership of a handgun. What they say is, and what they stamp on it is, not disapproved. Right? So if you do the paperwork, you do all the background checks, you pass everything, and you're not disapproved, you can then pick your firearm up after that 7-day waiting period. Now also on that note, you can only buy one regulated firearm every 30 days. So let's say you go to buy a handgun today, and let's say you find a good deal on one next week and you want to buy that one too. You can't do that until you waited 30 days. There is a way around that though. If you become what's called a designated firearms collector, you can then buy as many as you like. There's no limit. That limit goes away. And it's not extremely difficult to do. How you do that is that the only prerequisite for that is that you have bought a firearm before in Maryland. Once you've done that, you can take the piece of paper. The form actually is available on our website on PTPGun.com. You go and you download that form, you fill it out, you print it off, you fill it out by hand, you sign it in front of a notary, and then you fold it up and you send it off in the mail. It's simply relatively a check-in-the-box process. And last check was last week. I had a student say that they got theirs back within 24 hours. They got an email back from a representative at the state police saying that they were approved as a designated firearms collector, and they received a few short days later a physical version in the mail. So that's something I would definitely recommend that everyone in Maryland does. If you don't need it, hey, you don't need it. But if you need it, you got it, and you're able to use it. And again, it doesn't cost you anything. You don't have to have an application fee. You don't have to have fingerprints. You don't have to do training for it. You just simply fill out a piece of paper and send it off in the mail. The most it's going to cost you is what, 50 cents or so for the postage? Definitely get out there and do that. And again, you can download that form at PTPGun.com. So in Maryland, it is unlawful for any person to sell or transfer a regulated firearm to a person whom they know or have reasonable cause to believe that the person was under the age of 21, has been convicted of a disqualifying crime, is a fugitive from justice, an habitual drunkard, addicted to CDS. How do they know if you're a habitual drunkard or addicted to CDS? How do they gauge that? If you were convicted 3 or more times of an alcohol-related offense, and one of those were being in the past year. If you, for CDS, convicted of 2 more related crimes, and one of those being within the last 5 years. It's also a person's also disqualified from owning a firearm if they suffer from a mental disorder or have a history of violent behavior against themselves or another. Also, if they have been confined to a facility for more than 30 days for the treatment of a mental disorder, whether voluntary or involuntary. Or if the person was respondent from an ex parte or protective order. So if you are on the receiving end of a restraining order, protective order, however you want to put it, if you're on the receiving end of that, then you won't be able to buy, possess, own firearms, carry, or anything like that while that is active. If that were to expire and whatnot, you are then good after that fact. All right. Also, a person is disqualified if they're under the age of 30 and they were adjudicated delinquent by juvenile court for an act that would have been a disqualifying crime had it been committed by an adult. If they are at the time of transfer or purchase, if you are visibly under the influence of drugs or alcohol, or you are believed to be the participant of a straw purchase. Now, what is a straw purchase? Straw purchase is if somebody were to, let's say you were to have a friend or a cousin that says, hey man, you mind buying me that $500 Glock? Here's $600 and go ahead and keep the change. I'll meet with you next week to get it. If you were to partake in that, that is a straw purchase. You cannot do that. Right? Much like alcohol and minors. You cannot buy alcohol for a minor and then give it to them. Same thing. If they can't own a firearm and whatnot, if they want to buy a firearm, they need to go through the process of doing that. If they're prohibited from owning a firearm and that's why they're going through you, again, they won't be able to do it. So you buy a firearm for yourself. You're not buying it for friends or coworkers or whatever. All right? Otherwise, it's a straw purchase. Now, without a permit to carry a handgun, you actually can still carry a handgun at a limited amount of places. Private or residential property, whether it's commercial or residential, that you own or at least you get permission from. Like oftentimes, we might be on a property doing the shooting portion for a training course, and people are carrying firearms on that property. We have permission from the property owner. We're allowed to carry firearms on that property. Once you leave private property, though, if you're out on the major roadways, you're out at the store, whatever it might be, you have to have a permit to carry a handgun from Maryland for that in Maryland. Now, we'll go over where you can carry with that permit to carry a handgun, and then we'll go over the places you still can't carry. All right, so with that permit to carry a handgun, you can carry in public places not otherwise prohibited. You can carry in hospitals. You can carry in places of worship, sports arenas, gambling facilities, and polling places. And you can also carry in bars or restaurants where alcohol is served. Now, let's take a couple of steps back and we'll go over some of these more better. All right, so sports arenas, gambling facilities. Yes, you can legally carry in there. But many of them have prohibitions on that. So when you go in there, it says that you cannot have any type of weapons, firearms, or whatnot. And with that, they also usually have security, on-duty or off-duty law enforcement there to help enforce their policies. So it's still not illegal for you to carry there, but it is against their policy. And if you were to violate their policy, what would happen? A trespass citation. Right? Bars or restaurants where alcohol is served. While you can carry in a bar or restaurant where alcohol is served, you cannot carry while intoxicated. That is exactly how it's worded. So I could carry in Applebee's after church on a Sunday to get lunch with some friends and family, but I couldn't be able to drink and become under the influence while carrying that firearm. Also, take a step back. Polling places. Yes, you can carry in a polling place, but oftentimes where a polling place is located, not only schools, but specifically public schools. Oftentimes when I voted in Maryland, it was at a public school. And we take a step back to now the no's, that falls under one of the no's, so you cannot carry it. So even with a permit to carry a firearm, you cannot carry within 1,000 feet of a demonstration. You cannot carry on official state, multi-state, federal government facilities, or even grounds. What does that include? What's something that you deal with every day? Post office. So if you go to the post office, you cannot carry one into that post office, or even two, even technically have it in the parking lot of that post office, because that is the building and or the grounds thereof. You also cannot carry in daycare centers, but that does not include the in-home daycares. So example, I have two daughters. One is 1 and one is 5. The one that is 5 is in a public daycare, out in a public building, commercial building, and then the other is actually in an in-home daycare. I can carry while I'm picking up my child at the in-home daycare, but I cannot carry while I'm picking up the child at the daycare center in the commercial building and whatnot, out there in the public. So things to definitely know and understand. You also cannot carry in community rehab centers. So different ones you might have throughout your different communities across the state, you cannot carry in those community rehab centers. Now let's go into transportation of a firearm. All right? And I'm not going to kill you and read all this whole PowerPoint and tell you exactly what it says. What I'm going to tell you is, I'm going to sum it up like this. Maryland has taken your right to be able to transport firearms away. They have taken that away. They said you cannot transport firearms in Maryland. Whether in a boat, airways, waterways, whatever it might be, on roadways, you can't transport firearms. But wait, what they say is, no violation of that law, though, is committed if you can demonstrate that you're going to or from a legal place of purchase, sale, or repair shop. So you bought your firearm and you're taking it home, or you go in there to maybe sell it. If you're going between your residences. So let's say you've worked hard in life and you have your primary residence in one part of the state, and let's say you're going to Ocean City to spend the weekend at your beach house that you own. You could transport, not carry, you could transport your firearm between your residence, let's say in Charles County, to your home in Ocean City. Also, you can transport from your home to your business. You can go to or from formal or informal target practice. You're going to a class with us for the day 2 shooting portion. Whether you're going to a sports shooting event, also hunting, trapping, or dog obedience training class or show. So if you're transporting your firearms, you're going out to the field, you're going out to the woods to go out hunting, and or you're coming back, that is also a legal exemption too. So if you can demonstrate that you're operating in one of those facets, you are not violating the law. Now, an additional thing that you could possibly have is, we talked about being a designated firearms collector. So if you're a designated firearms collector, you can also, with that, you're able to transport any their part of your collection for private or public exhibition. So example I like to bring up. Let's say you leave the gun shop with your next firearm that you just bought, and you're really excited about it, you're really proud, you want to stop by maybe show one of your buddies, because they were looking at one too. So you want to go ahead and show them real quick on your way home. You stop by Bobby's house, you show them your gun, and then you leave and you're headed home. Well, if you're not a designated firearms collector, you just violated the law, because you are no longer leaving, ABC Guns and headed to your home. You're not leaving Bobby's house and headed home. But if you're a designated firearms collector, what you can reasonably articulate is that you are moving any part of your gun collection from place to place for public or private exhibition. So with that being said, what you're articulating is, you are displaying, you're privately exhibiting that firearm to Bobby, and now you're leaving that private exhibition and you're headed home. Now, on that note, you're not going to articulate that at all. You're not going to bring that up at all, because you're going to shut up and lawyer up. And we're going to talk about that more later. So commercially made firearms have serial numbers indicated on them. That's required by law. On Glocks, you'll find them on the bottom of the frame right here. That actually indicates, again, it's unique to each firearm. That serial number, you cannot mess with that serial number at all. You can't paint over it, you can't scratch it out, take a Dremel to it, nothing like that. If you do, you're going to be in violation of the law, and when you get caught, you're looking at big time. So never mess with that serial number at all. You'll notice sometimes, like on Glocks, they also put them on the barrel and the slide. That doesn't matter at all. What it matters is, again, the serial number on the frame. And they got to be required on the frame of any firearm. Whether you're talking about a AR-15, a Glock, or whatnot, it's always going to be located on the frame of that gun. So don't mess with the serial numbers on any type of firearm. So if I assault you, that's a crime. If I assault you because of your race, your religion, your gender, your political affiliations, that's a hate crime on top of that assault. If I commit a robbery or whatnot, that's a crime. If I use a firearm in the commission of that robbery too, that's an additional crime on top of that, and they're going to get additional time for that charge as well. Now, it is unlawful for a person to store or leave a loaded firearm where they knew or should have known that a person under the age of 16 would gain unsupervised access to that firearm. Now, if the person is certified, they got the hunter safety course, or they've taken another certified training course, they are exempt from that. Also, you wouldn't be held liable if they gain that from a robbery. If they break into your home, they break into your safe, and they steal your gun, you wouldn't be held liable for that. But generally speaking, anyone under the age of 16 can't have unsupervised access to a firearm. Now, if you have a firearm in the home, and you have it there for home defense, let's say, you need to have a good, healthy balance between access to that firearm, but also security of that firearm. Because, again, if you have it for home defense, some places and some people might say, oh, you need to have the firearm unloaded in a safe over here, and you should have the ammunition completely separate. But again, what good is that going to serve you if you need it in your time of need for a home defense situation? Right? So you need to keep a good balance between that. You don't want to just have firearms laying all around the house and stuff, and where my 1-year-old or my 5-year-old can gain access to it. But I also have to have reasonable access to it myself. So how you do that is a case-by-case basis. You got to figure that out on your own. What works for you and your family. Not everyone has the same situation going on. At one point in time, I didn't have any kids, just wife, me, and the 2 dogs. And I maybe store my firearms significantly differently than I do now. Now, I have, my personal defense gun that I carry. That's either on my person at the home, or it's very close by in a secured manner that I have decided that works for me and my family. But you got to decide what's going on with you. You may not have kids in the home, but you may have grandkids that visit. You might have other individuals that might visit. It might be kids. It might even be every family has that one family member, or maybe that friend that has sticky fingers. They don't know how to stay out of trouble. And so even with those people around you, again, you want to have it secured from them as well. So there's different ways you can secure your firearm, whether it's a large safe or whether it's something small that you keep by the bed. Whether you have something large or small, you want to make sure that you have it bolted down. Because it's a big, huge, heavy safe with a bunch of items in it, and you can't barely move it yourself. You want to make sure that you still have that bolted down. You got to think like a criminal, right? There was an example one time where a gentleman had a big safe in his garage, and a individual came and when he wasn't home, I think they strapped the garage door to their truck, ripped the garage door right down. Then they backed on up, tied that same big ass tow strap around the safe, and ripped it right out of his garage. And they loaded it as quickly as they could onto a flatbed trailer, and they were out of there. So you want to make sure that you make it as hard as possible for somebody to be able to gain access to those firearms, or to be able to take that whole safe. If you have all these nice, cool little safes that you can have right by the bed that read your fingerprints, or it's got a little keypad code or whatever it might be, that's all great and dandy. But if it's not bolted down, if it's just sitting out in the open on your nightstand or whatnot, and I break into your house and I want to, I'm just going to take and pick that thing up, put it in my vehicle, and I have all the time in the world at home to be able to break into that. So while it might be secured in that safe, it might be impossible to get into that safe maybe in a timely manner in your home. You want to make sure they can't get it out of the home too. Now, there's different ways to gain access into your safe. There's a whole lot of things out there available, and what you choose is up to you. There's ones that simply just have a key. There are ones that have the old dial you might have had on your locker at school growing up. We have to turn it, one way, hit the number, the other way, hit the number, third back, and hit the number. And I don't personally like those. I remember growing up in middle school and high school having a locker, and I always mess up that code, that combination. And, you have to restart, flip the whole thing around 3 or 4 times, and then restart. Wasn't a fan of that growing up, and I'm not going to, if I had a choice, I'm not going to use it as an adult to get access to my firearms. So what I've chosen is what you might see here. We have an electronic keypad, and you just put my 7-digit PIN in, and I can gain access to it pretty quickly. And because of my line of work, I get in and out of that safe very often. So it's not very difficult for me to remember my code. I could physically put it in quicker than I could tell you and recite it offhand. And that works for me. And also with that, for those that are not familiar, so it's battery powered, and the battery is on the outside, on the back face of that dial. So what I can do is if the battery were to die and I need to get access to my safe, two options. One, I can just take the face off, change that little battery out. It's type of the square one that you put in your smoke detectors and stuff. Or if I don't have extra battery and whatnot on hand at that moment, I have a key backup. That's also the keyhole is behind that face. So I can just put my key in and turn it and unlock it that way. So I've got a redundancy plan there in place. So that works for me. But what works for you, you got to find out that. I've also seen out there where they have, like you put your hand on there and you can hit the thing with your fingertips, or I've even seen ones that read your fingerprints. Particularly myself, I'm not a big fan of that. I used to have a phone not too long ago where you can use your fingerprint and gain access to your phone to unlock it. And many times, there were times where, for no reason at all, I wasn't under stress, my hands were relatively clean, but I didn't get my fingerprint on in the right way at the right time, and it wasn't able to unlock. And I've had other times where I got maybe dirt on my hands or whatever it might be, and it wasn't able to read my fingerprint. And I don't want that same type of technology and those same failures to happen to my gun safe when I'm trying to gain access to my firearms, possibly in my time of need. Maryland House Bill 1302. That is Maryland's red flag gun confiscation bill. That was signed into law by Governor Larry Hogan on April 24th of 2018, and it went into effect October 1 of 2018. What that law generally does is it allows petitioners, which petitioners can include, but it's not limited to, spouses, relatives, roommates, people that you might share a child with. They say you maybe weren't in a relationship with them, but you had a child with a person. That person is included as well as a petitioner. It also can be someone that you're in a relationship, a former legal guardian, law enforcement officers, and or a physician that has examined that respondent. And what the petitioners are afforded is their identity is never disclosed to the respondent or the public. So you can make an anonymous report against somebody, whether based on fact or even based on fiction. And what that allows you to do is if the courts decide, they can take and use that to confiscate the firearms from a person who has not committed any crimes, who is not committing any crimes, not made a threat of committing any crimes, someone who otherwise could not have their firearms confiscated from them. The person, the respondent of one of these extreme risk protective orders, they would have no idea that this is going on until the cops show up at their place of residence or even business in order to confiscate those firearms from them. And now the ironic thing and I don't want to say funny, but the funny thing about it is that this bill is only about confiscating firearms. If that person that's thought of as being a risk to themselves or others, they can confiscate their firearms from them, but they won't confiscate knives, swords, hammers, vehicles, or other devices, other inanimate objects that can be used by that person in order to be a threat to themselves or others. This is simply a gun confiscation bill. And again, this is not for felons. This is not for domestic abusers. This is not for any of that. This is for someone who is abiding by the law, has never broken the law, and they can't otherwise confiscate firearms from them. So they had to make this law in order to do that. It's obviously a big threat to your rights, not only your constitutional right to keep and bear arms, but it also takes away your due process. Your rights are confiscated from you. Your right to keep and bear arms is confiscated from you, and you do not. You have an opportunity to fight to get those rights back, but they may very well retain your firearms and prohibit you from owning firearms or buying new firearms for even up to a year. Now, some police departments, when they do that, obviously they're confiscating your guns, your ammunition, magazines, stuff like that. Baltimore City particularly, they have a policy where if they were to confiscate anything from you, they never return. Their policy, not law, but their policy is they don't return your ammunition at all either. So even if you were to found to be not a threat to yourself or others, not any type of problem, you get your firearms back after they've been confiscated from you, you won't get your ammunition back. This is a total slap in the face to your constitutional rights, and not only that, but specifically your right to keep and bear arms and due process. This obviously can be repealed with your voice. If you were to speak to your lawmakers and have your voice be heard, this potentially could be repealed, but time will tell on that one. So now we're going to talk about judicial precedent rather than statutes. We're going to talk about castle doctrine, stand your ground, middle ground, as well as duty to retreat. Now, when we get into this portion of the class, we're going to have to know certain definitions of how Maryland exactly defines this, because that's going to be a big thing when it comes to the courts if you have to make it that far. All right, so Maryland, how they define deadly force. Deadly force is the amount of force reasonably calculated to cause death or serious bodily harm. All right, so what does that mean? Deadly force, let's break it down. Deadly force is the amount of force reasonably calculated to cause death or serious bodily harm. So if you reasonably fear that someone's actions are going to cause your death or at least something else, serious bodily harm, then that is deadly force. And can we use deadly force in defense of deadly force? Absolutely. We'll get into that in a moment, though. So outside of one's home, right? Outside of one's home, a person, before using deadly force in self-defense, has a duty to retreat or avoid danger. Caveat to that is if such means were within their power and consistent with their safety. So yes, in Maryland, you have a duty to retreat outside of your home. Right? Outside your home, you have a duty to retreat or avoid danger. But if the means to be able to do so, if the means to be able to escape that danger, avoid danger, retreat, if that means is not within your power or consistent with your safety, you do not have a duty to retreat. Example, right? So I taught a gentleman at one point where he was probably in his mid to late 70s, and he was a double amputee from the knees down. How he got in and out of the class was with this mobile, what do they call it? It was a red mobility cart. Right? With that strongly limits his ability or his power to retreat from any dangers. Could he still possibly retreat from certain dangers? Yeah. But may he not? Absolutely. Also, another thing, it could be perfectly within your power, but maybe it's not within it's not consistent with your safety to be able to do so. So while I could turn and retreat from this gentleman that's run at me with a knife, I could turn and run this way, but on this other side of myself, there are 4 lanes of traffic. Is it consistent with my safety to run across 3 to 4 lanes of traffic? No. So in that, I would not have a duty to retreat. I could, per se, stand my ground. So again, you have a duty to retreat outside your home only if it's consistent with your safety and within your power. Now, inside your home, a man or woman faced with danger of attack upon their dwelling need not retreat to the home to escape that danger, but instead may stand their ground, and if necessary, may kill the attacker. Right? So what does that mean? If you're in your home, you do not have to retreat in order to escape the danger. You could stand your ground. All right? And if you absolutely have to, if it's required, if it's needed, in repelling that attack, you may kill the attacker. Now, no one watching this is wanting to, no one in their right mind is wanting to take another person's life. That's nothing that you ever want to do. That's nothing you ever seek to do. No reasonable person wants that. I don't want that. I don't leave my home. I don't put my gun in my holster and leave the home and like, all right, today's the day. Hopefully I'll get to shoot somebody and kill them. Like, this is what I've trained for all my life. Yes. No, that's not it. That's not reality. All right. Nobody wants to do that. Right. But don't get me wrong. If I need to, if I had to defend myself or my loved ones, absolutely will. All right. But again, it's not something I ever want to seek to do. It is a justifiable homicide to kill to prevent the commission of a felony by force or surprise. Now, if other methods could prevent its commission, that homicide would not be justified. All other means of preventing that crime must first be exhausted. A great example of this I like to bring up. There was a shooting on December 29th of 2019 at the West Freeway Baptist Church. I believe it's actually the Church of Christ in Texas. And what happened there, you'll be able to see in the video, what we see here is the gentleman comes to the rear of the church. The subject comes to the rear of the church. He has a few words, and then he takes out a firearm, and he shoots 2 individuals. And he turns and backs the other way, and he goes to continue his shooting spree. A gentleman in the room, a good guy with a gun, Jack Wilson, then goes and draws his firearm out, and he then discharges that firearm, shooting the gentleman, and striking him once in the face. Right? Why was that legal? Did he use all other means of preventing that crime? He didn't. but they weren't able to be reasonably used. He couldn't reasonably sit there and give the guy verbal commands, use strikes on the guy. Any other things wouldn't be reasonable. So he went straight for his use of a firearm and discharged it at the gentleman's face because all the lesser means would not be reasonably used. All right. So in that case, the homicide was justified, and as you see here, very evidence in the video from that scene. Now, it doesn't matter where you're at. It doesn't matter whether you're in your home, in your vehicle, in your church, in a school. It doesn't matter where you're at. You cannot be excessive. It doesn't matter who you are, where you're at, who you think you know. Right? You cannot be excessive. You have a responsibility not only to yourself, but the community and those around you to be a reasonable and prudent person. That doesn't mean that you couldn't use your firearm and potentially want to, but you wouldn't. Doesn't mean you can't potentially take another person's life. You just cannot be excessive. Example, let's say that the Jack Wilson from the church shooting, he shot the gentleman once in the face from across the room. That terminated that threat. He came up to the threat, took the firearm to the side. That threat was eliminated. All right, and that was perfectly reasonable and justified. Now, if he were to come up on the gentleman, disarm him, and the guy, again, was out of the fight. That guy was totally out of the fight. But if he were to now unload second, third, fourth, 5 rounds, into that gentleman, that would be excessive. You might say, well, the guy was going to die anyway. Why does that matter? Exactly. If the person's going to die anyway, why would you have to shoot more than otherwise? Not to say that you only need to shoot 1 round. It might take 5, 10, 15, 20 rounds. You never know. It might take more than 1 round to eliminate a threat. But once that threat is eliminated, you cannot continue on. You cannot be excessive. All right, again, it doesn't matter the context. It doesn't matter who you are. All right, you cannot be excessive. All right, and again, that's different for each situation. You could, in that situation, if he would have fired a second or third round, that would be excessive. In some situations, you might fire 30 or 40 rounds and not even be close to being excessive. So it's all by situations, and I can never tell you about a situation and say, yeah, if you were to do that, you would not be excessive. It's all hypothetical. Now, using deadly force is only an extreme necessity, like that church shooting. Only an extreme necessity as a last resort. It can be your first resort, again, like in that church shooting, that was his first and his last resort because nothing else lesser than that would work. As a last resort, when all lesser means have failed, or in that case, couldn't have been reasonably used in the first place. You cannot, just because you have your firearm on you, just because you're concealed carrying, doesn't mean that is the right choice for every situation. 99% of people will never need to pull their firearm out. But you want to make sure that when you do, that you're not being excessive. Right? You want to make sure that it's an extreme necessity as a last resort when all other lesser means have failed or you couldn't use those lesser means in the first place reasonably. Now, let's say for some reason you were to defend yourself and the cops disagree with your assertions. The DA decides to bring it before a grand jury. The grand jury decides to indict you, and now you're on trial for, let's say, assault with a deadly weapon, or let's say the person died and you're on the stand for murder or some variation of that. All right. These are the instructions that are going to be given to the jury. All right. So if you're claiming self-defense, that can be a claim. If you're claiming self-defense, the defendant must be found not guilty if all the following 3 factors are present. The defendant actually believed that he or she was in immediate or imminent danger of bodily harm. The defendant's belief was reasonable. What you are saying you did, it has to be reasonable. All right? Again, it cannot be excessive. The defendant used no more force than was reasonably necessary to defend himself or herself in light of the threatened or actual harm. Defense of others. Very similar. Not much difference. Right? You can defend other people. You don't have to know them. You don't have to ever met them. You don't have to be related to them. Nothing like that. You can defend others. And if you're using defense of others as a defense, the defendant must be found not guilty if the following 4 factors are present. The defendant actually believed that the person defended was in immediate or imminent danger of bodily harm. The defendant's belief was reasonable. The defendant used no more force than was reasonably necessary to defend the person defended in light of the threatened or actual force. And the defendant's purpose in using the force was to aid that person defended. Right? Now let's talk about property. You can defend property. You cannot defend property using deadly force, but you can defend your property. All right, what does that mean? You got to think about it like this. All right, if you were to take your kids to the aquarium, your kids, your grandkids, whatnot, you take them to the aquarium and you're looking at the sharks and stuff, and it's all cool and dandy, but you drop your keys or your wallet or your cell phone in the shark tank. Are you going to jump in after it? You're going to try to dive in there and get that expensive item out of there? Or are you going to get your wallet because you don't want to have to sit in the line at the DMV and do all this to get all those items back? No, because it's not worth it, right? Same thing. All right, now if your kid falls in the shark tank, you got to think. You got to ask yourself, which kid is it? No, but on a serious note, your kid is a totally different thing. You would not even hesitate to jump in there and save your child, even if it puts your life at risk, because it's that important. It's life or death. It's a person's safety. Whatever you might have seen on Shark Week, you're going to jump in there and punch that shark in the nose, whatever it might be. Do anything possible to defend your child, and that's the way you got to think about it. Possessions, you definitely want to, at times you might want to defend them, but sometimes it's not worth it. All right. Thing I kind of half-heartedly use is, hey, if somebody's out stealing my truck, I see my truck's getting broken into, and they're trying to steal my truck, is it really worth risking my life over, or possibly taking somebody else's life over a truck? I've got insurance, all right? What would be a better outcome? Let's think of two different outcomes. Let's think of two different extremes, all right? I go out there, and I intercept the person. I don't have my gun out because I'm not defending property. But let's say I grab the person out of the vehicle, I throw them to the ground. We exchange a few punches, and I'm holding them to the ground. And somebody comes out the door, and I'm like, hey, call the police, get the cops here, blah blah. And that person don't want to be held there when the cops come. They want to get the hell out of there. But you're overpowering them. They can't get out of there. They want to just get the hell out. So what do? Let's say they pull out a knife. They take out a knife and they start plugging at you. Not because they're trying to hurt you or kill you, really, although that's obviously a possibility, but just they want you to let go so they can get the hell out of there. All right? Now, in that case, you're not defending. If you were to pull your gun out then, you're not defending your property. Now you're defending your life. So let's say you pull your gun out and now you shoot this person a few times. Let's say they die. And while you might be perfectly in the right, and you're going to have to deal with the cops, you're going to deal with lawyers, you're going to deal with possible criminal prosecution, you might have to deal with civil suits and whatnot, and you might make it clean and easy out of all that. You might, but you might not. But in either case, all the stress and the financial problems that come with that, nobody wants all that. It's not just as simple as you shoot somebody, you defend yourself, you go home, you go on with your life. It's not that simple. It's not that easy. So that's scenario A. Scenario B, I let them steal my truck. Not helping them and stuff, but I don't intervene. Maybe I get a few pictures and video of it and stuff. I get it to the cops. They never recover my truck. Next week, next month, whatever, I get a check from the insurance company to go out and buy myself a brand new truck. All right. Hey, it might sound half jokingly, but sometimes you got to think smarter, not harder. Don't put your life at risk, for property. Don't put yourself in that situation. It's not necessary. It's not required. Especially if you have insurance on the thing. Just let it go. Let it go. You got to think smarter, not harder sometimes. All right. Now, general rules. The 4 general rules that need to be present when you're using deadly force. All right. You have actual fear of death or serious bodily harm. You are the innocent party. You can't start the situation. You can't start a fight. All right. Lesser force would not suffice, and escape is not possible. All right. So let's break that down a little bit. Again, you have to be in actual fear of death or serious bodily harm. You can't just shoot somebody just because they pissed you off. You can't shoot somebody because they decide to get in a fight with you and you don't feel like throwing down. You cannot start a fight, get your tail whooped, and then be in fear for your life and say, oh, now I'm going to shoot this person. All right. If you can stop whatever situation is going on with lesser means, then by all means, absolutely use those lesser means. Don't just use your gun just because you have it. All right, it's there if you need it, but do not just resort to it every single time because that's there. Why wouldn't I shoot them? Because I got my gun? No, it's not how it works. All right. And again, escape not being possible. Hey, if you can escape the situation and nobody's innocent lives are going to be put in harm's way because of that, then escape. Do it. I mean, again, you got to think smarter, not harder. If you ever use force or threaten to use force even, you want to make sure that 911 is called. Now, if you can't avoid it, you want to make sure that somebody else can call for you. You don't want to be on that 911 call. Why? Because that is being recorded. And anything you might say during that call can be used against you later. Not to say that you did anything bad, but how you say things can be, how you say things or what you say, the words you choose can be definitely used against you. And if you can avoid being recorded at any time, that is optimal, all right? But let's say you have to call. Let's say there's no one else there. You call 911. You keep it short and sweet. They're trained to keep you on the phone, extract as much information out of you as possible. They're going to try to keep you on the phone, keep you talking. That is not your responsibility. You are not required by law to do that. Give them what they need, not what they want. Generally speaking, you want to tell them that you were in fear for your life and you had to defend yourself. You want to make sure that they know what you look like. They want to make sure that you know the subject looks like. You want to make sure that you have the address of where you're at. You want to make sure that you request not only law enforcement to show up, but also an ambulance, whether for yourself or even for that subject. And it wouldn't be a bad idea that when the ambulance gets there to at least get yourself checked out, because they might be able to catch things that you did not even be aware of during that situation. After you've hung up on 911 and they've got these services on the way, you want to make sure that you go ahead and call your attorney. That is very key. Right? You call your attorney and get them at least know that something happened, and they're going to get their way out to you so they can start their representation for you. And then also, you want to make sure you call your family, because you may not be with them at that time. It may have happened when you were out in town, and they might know, hey, Ryan went out to this particular place, and oh, look, on Facebook or on the news, here's a situation that just happened a half an hour ago. Ryan was there. Let me call to see if that person's all right. They call me. I can't, my phone may not be with me. I might have left it in the vehicle, or I'm being questioned by law enforcement, and they are stressing for, however many time, wondering if I'm all right. So you want to make sure that, one, you let them know that you are all right, that you'll make it fine. Two, you want to make sure that they know that you do not consent to any searches, because if law enforcement were to show up to your place of business, they show up to your home, and they were to ask your spouse, family member, your child, and they let them search your home, they let the cops search your garage, your vehicle, your office, anything they find during that search can be used against you. So you want to make sure that you understand, and that your family and your friends and your coworkers understand, that you do not consent to any searches. Now, if law enforcement have a warrant, absolutely let them do what they got to do per that warrant. But do not allow them to conduct a warrantless search on your house by getting permission from a family member. And again, someone, even your daughter that's 9 years old, opens the door and says, "Oh yes, come on in." They will be able to use that against you. So you definitely want to make sure that they understand that and know that, and that your lawyer gets involved in that side of things as well. Best advice I'm going to be able to give you during this portion is to shut up and to lawyer up. Right. That's not an anti-cop statement. That's not saying that cops are out to get you. That this or that. Why I'm saying that is because you just took an action to defend your life. You did what you had to do to defend your life and those around you, and now it's your lawyer's job to defend you when it comes to possible criminal prosecutions and or civil suits. And the best thing you can do to help your lawyer is to shut up. To shut up. Nobody has ever talked themselves out of jail, but people oftentimes have talked themselves right into jail, right into the handcuffs. You have a Fifth Amendment right. Exercise it. Right? Say you just shot somebody. Say you just shot and killed somebody. Do you think you're in the best mental state to provide, statements that can be used against you to put you in jail, possibly for the rest of your life? Do you think you might need a little bit of time to decompress, to calm down? Absolutely. Right? Oftentimes you'll see where law enforcement are involved in officer-involved shootings in the line of duty. And what happens with them, a lot of times, nearly every single time, it's standard that they're put on administrative leave. They get a couple days to kind of decompress, to consult with their lawyers, their union reps. You have that same right too. You don't have to say anything. From start to finish, from the time you were to defend yourself to the very end of your life, you could never ever make a statement about that situation, and that is your legal right. Right? Your lawyer will be able to better advise you on what to say and what not to say. Generally speaking, you're going to be explaining to your lawyer what you saw, what you heard, what you felt, why you did what you did, and what your lawyer's job is going to be generally to do is they're going to help you articulate what you did in a way that shows and proves, right, that what you did was within your legal right, right? Because you might explain yourself the wrong way. You might say exactly the same thing, but you say it the wrong way, or you say too much, and it might be used against you in a court to paint a visual of how maybe you weren't in the right, maybe you weren't quite sure. So again, you want to limit those discussions, and you can do that in a reasonable manner. You know, if you're talking law enforcement, your lawyer's not there yet. Hey, I understand you have a job to do. I understand you want to talk to me about a few different things, but I would like to wait. I would like to exercise my Fifth Amendment right to remain silent. And I'd like to wait until my lawyer is here to make any further statements. All right? They're going to ask you things. Even after you say that, they're going to say, hey, that's cool, I got you, but, at least tell me a few different things like how many rounds you shoot. They're going to ask, they're going to try to pry. And just, again, respectfully say, hey, I respectfully decline to answer any questions at this time. I want to go ahead and exercise my Fifth Amendment right, and I'd like to wait to talk to my lawyer before I give any type of statements. Right? Example of why that might be. Again, it's not that law enforcement are out to get you. It's not that they're bad people. They have a very thankless job. But if you were to let's say you were to shoot and possibly kill somebody in self-defense, do you think that only one or two cops are going to show up to that scene? No, you very easily could have a dozen cops show up on that scene. And cops, just like anybody else, are going to be very nosy. You might have every one of those dozen cops come up and talk to you and ask you what happened. And let's say you tell all of them the same exact statement about exactly what happened. Do you think they're all going to remember it the same way? You think they're all going to hear every little bit and the next morning, let's say they get together and they have a meeting and they say, all right, so let's talk about that shooting from last night. And Bobby over here says, well, yeah, they told me this, blah, blah, blah. They're like, whoa. And Steve over here, or Susie, are like, oh, he didn't say that to me. He said this. Because they remembered it a little bit differently. They grasped from a certain parts a little bit differently. I guess not so much that they're bad people, that they're out to get you, but words can be mixed up, misremembered. And again, you can avoid all that by providing zero statements at all. And wait until you consult with your lawyer. You guys have sat down, you've discussed everything, you've figured it out, you've gotten your statement even written down and prepared, and then you provide one recorded statement. If everyone says, nah, he didn't talk to me for anything, she didn't say nothing to me, they can claim their Fifth Amendment right. Well, hey, Steve over here 3 days later got a video recording of your prepared statement of the events of that night as you best recall. If that's the only thing they have to go by, all right, stories can be mixed up. That's the only statement they have to go off of. So that's an example of ways that talking to too many people, talking without consulting your lawyer can really do more harm than good. Now, a lot of people might say, because you talk about lawyers a lot, Ryan, you said shut up and lawyer up, shut up and lawyer up. Lawyers are expensive. I don't have a lawyer. And just to get a retainer fee on one, they're $5,000. You're absolutely right. Lawyers can be very expensive. But I'd rather have a lawyer and pay those fees and whatnot than to end up in jail. Now, there are options out there, though. And the one that I've chosen is what's called U.S. Law Shield. U.S. Law Shield, whether I'm not a sales rep for them, I'm not a representative of theirs, but it's definitely a strong tool that I recommend to a lot of my clients, and I've used it myself. I still have my membership. What it is here's my wallet. One side of my wallet, is my payment cards and whatnot. The other side, I have my U.S. Law Shield card, and behind that is all my permits and whatnot. Why I have U.S. Law Shield? What is it? I think of it as insurance. And what it is more or less is it's $10.95 a month. And what it is you pay $10.95 a month, and there's deals and stuff out there, but $10.95 a month, you pay that, and hopefully you don't need it, just like insurance. But if you need it, let's say you call 911 because you just threatened to use force against somebody, or you did use force. Your next phone call, when I said call your attorney, you can go ahead and call U.S. Law Shield. They give you a membership card. When you get on there, you get a membership card, and The front has my membership number. I have a Virginia-based membership, but with my Virginia-based membership, I had the 50-state coverage. But it has my membership number on the one side, and on the back, it has a black number and a red number. If you just got the phone with 911 and police are on their way, the red number is what you want to call. Red number, you call, then you give them the short and sweet. Hey, I just defended myself, and I need your services. I'm a member. Here's my member code, and I need you to send me a lawyer right now. And their general guidelines is they want to have a lawyer out to you within 2 hours. The lawyer that we use, that they have in Maryland a lot is Terrence Decker. The lawyer that I've talked with in Virginia is Gilbert Ambler out of Winchester, Virginia. But these are lawyers that know what they're talking about. They have experience. You don't want to use your cheap lawyer that you have from a divorce from 5 years ago. You don't want to use a lawyer that got you out of a few traffic tickets here and there. You want, in this type of scenario, you want a lawyer that knows about criminal law. You want a lawyer that has experience with firearms related situations or self-defense related situations, that know their stuff, because this is a matter of you going to jail for the rest of your life potentially, or you going home. Which would you rather? All right, this is not a time to cheap out. But again, with U.S. Law Shield, you don't have to spend a big boatload of money. $10.95 a month gets you your base membership out of the state of your residence. And if you wanted to, you can spend an extra $3 to get 50-state coverage. It's great. I've never had to use it in that manner. I hope I never do. What I have used it for is the black number here. It gives you a phone number, and you can call if you have questions. So if you're not sure about something, is my permit to carry from Maryland, is that valid in Virginia? If I'm going down to a wedding in South Carolina, how can I transport my firearm legally through the states on my drive down there? You can call that black number and they'll answer your questions. You get it from a legal professional, not some YouTube video or not on some website on the internet, because of course everything on the internet's got to be true, right? No. But again, if you're getting legal advice from your lawyer, all right, that's a lot. I would rather trust that a lot better. All right, so U.S. Law Shield is a very good option. There's several options out there. This has been the best option that I can find. I've looked at other companies, and for various reasons, I didn't go with them. One of the big ones, especially when you talk about Maryland and Maryland law, one of the big reasons why I didn't go with one of the other services is because they don't cover red flag confiscations. That was a big thing that helped me not only choose to be with U.S. Law Shield, but to stay with U.S. Law Shield. And if you go, I'm going to try to provide a link for this as well, but if you go to their website and you use promo code PTPGun, I believe they give you a certain deal. I don't know what it is. I want to say it's like a month free or something like that. But use PTPGun at the checkout and you'll save even more money. You can pay it annually or you can pay it monthly. Those who are part of our PTP Gun Club, you all understand how valuable this is. With our PTP Gun Club membership, you get a base membership for your state of residence. And if you wanted to, you could obviously add on the coverage for your family. You can add on the coverage for the 50-state coverage. You can add on, they even have Hunter Shield as well. And there's more details on that on their website. Look onto that. But again, when you sign up, make sure you use PTP Gun as your promo code, and that'll also give you a little bit of a deal on there so you can have further savings. So thank you all again for joining us for this presentation. Be sure to follow us on Facebook and Instagram at PTPGun. Also, you can find us on YouTube at PTPGun.com, Firearms Training.